In the never-ending quest to cut corners, they cut corners that they cannot cut. And one of the corners that I see happening, and it sometimes is almost subconsciously, is people feel because it's an open book test, they don't have to learn the material as well. And this is exactly backwards. You actually have to learn it better. So if there's any sort of niggling idea in your head that, well, I'll just put this in front of me and then if I need it, I'll pull it on the test and think that that will do, it will not. And the reason why that doesn't work is because you won't know to look at things or understand things if you don't know the material really, really, really well. The midterm exam is, to me, considerably easier than the final exam, so I'm trying to introduce you to the thought process for both of them. They both have the same issue, and it's much more true in the final exam. You have to learn the material so that you don't need the written stuff. You have to learn at that level. And the written stuff that you can bring in should be a safety net. You're allowed to bring any written material you want. You cannot bring any electronic devices at all unless they're approved by me. You're not allowed to have your cell phone in any way, shape, or form. You're not allowed to have smartwatches. You're not allowed to have that stuff in an exam. Okay? So, yeah.
When you say written, do you mean written or can that include printed?
Anything, yeah. What I mean by written is anything that is on a piece of paper. Okay? I don't care how it got there. Okay? As long as it's not your cell phone on a piece of paper, right? As long as it's in a paper format, so you can bring your textbook, you can bring your notes, you can bring sheets that you've printed off, you can bring anything. But again, it's so important you recognize when you walk in here relying on those, you walk in here unprepared. You're not prepared properly. And getting your stuff organized is part of the skill of getting ready for an open book exam. So if you just bring in your notes with all the stuff and the dates and stuff, you're not prepared. There's stuff you're going to need, right? And you should have that sitting there in a nice, easy to accessible format. I've written open book exams myself. I'll tell you what I did. We used to have basically a textbook, and we had case books, which were full of cases, and we had class notes, and those were the three principal things that we had. And what I would do, because this was before the day of computers when I was doing this, is that I would go through the textbook from end to end, everything we took, and I would rewrite it in my own words, everything, right? So I have written the textbook out in my own words, not rewritten it. I've written it in my own words. What does this mean? What does this thing? What do they? And then I would go through the cases, and I would say, okay, what was this case about? What was this? And I'd have that. And then I would go through the class notes from the class I had and wrote all them out, rewrote them all out. And now I've got these in my own handwriting in 3 places, right? And then I would take them all and combine them into one massive document. It's got everything in it, right? So I put them all together. Then what I would go through is I would go through and take this massive document that might have been 250 pages of written materials, and I would bring it down to 30. And then I would take that 30 and I would bring it down to 8. And then I would take that 8 and put it down to the one piece of paper I know I'm going to need. And everything is cross-referenced. So the one piece of paper will refer to the 8 will refer to the 60 will refer to the 250. So if I say, I don't understand what that is, I need this, I can go back and find it. But it's all organized. So you can't just show up, bring your notes, put them down, and say, okay, let me see the test. You're not ready for it. And you won't do as well. You might be able to get away with it a little bit. That's the problem with this test coming up. But in the final, you will not be ready if you don't know your stuff really well. Okay? All right. With that in mind, what I would like to do today is finish off the class material, stuff we haven't done. And because I need to be able to tie to the elements of negligence, I've written out a negligence on the board. Before I erase this, because I'm going to have to, I will give you an opportunity to take a picture if you want, or something like that, before I erase it. You can do that at some point in time. But you need to understand what we're doing and why we're doing that. And then, after I finish the material, I will either address any questions you have, or I will go to the case study and we will walk through a couple of the torts, doing them properly. This is so important. Suddenly people go, okay, now I get it. Okay? At this point in time, it's a pretty important class for the lights to go off, or on. Oh, sorry. On. The lights go on. One of the things that some of you pointed out that we hadn't done, thank you for pointing that out because I would have missed it, is we never went through a constitutional flowchart that I asked you to do. And I don't think you could do this by yourself, because, well, you might have, but don't pat yourself on the back. It's pretty hard, okay? So, when we're dealing with the constitutional question over here, if you've done this right, every topic that we talked about with respect to Constitution should be up here. Everything that we talked about should be up here. Because if that's part of the answer, you have to have that piece there. Do you understand what I'm saying there, folks? If it's a constitutional question, you must have everything we've learned about the Constitution up here to have the ability to deal with a question about anything. Because if all the topics are up there, one or more of them is going to be what you need to deal with. And if they're all up there, then the answer's up there somewhere. So, if you have identified a question on the test or anywhere else as being a constitutional question, and that's kind of sometimes the hard part, you got to understand this is a constitutional question. This is one I need this material to answer. Right? So you've identified it as that. And on an open book exam, that is often the way you're being tested. Do you know what this is? Do you know this is a constitutional question and I got to use this to answer? Or it's a torts question, or it's a defamation question, or it's a common law question. You got to be able to understand stuff well enough that when I ask you a question, you go, that's about this. Once you've done that connection and gotten it right, the rest is generally fairly easy. So if I gave you a question and you say, oh, okay, this is a constitutional question, then you would have to use the flow chart. So I said you take that question, and the first thing that I would identify are the facts in here dealing with a statute or a behavior? So there's a law, and here there's no law. So you got to look at the facts and be able to tell that. It should be apparent in the facts. So if the facts are disclosing a law, you should go over here. If there's no law, you're over there. Then, if we're over to this side, the second thing that I would ask, now there's different ways to do this, but this is the way that I would do it, okay? Is, did the right government pass the law? This is using Section 91 to 92, the Constitution Act of 1867. That's what you use to answer it. But the question is, did the right government pass the law? Did the federal government pass a law about something that was given to the federal government? Or did the provincial government pass the law about something that was given to the provincial government? Did the right government pass the law? So if you look at the facts, you say this law is about what? Give me something. Healthcare. And it's the federal government that passed it. Well, you've got to understand this well enough to know, right? that does the federal government have the right to make laws about health care? So that would put you to here. And this is actually an end point, because you can tell now what happens if the wrong government passes the law. Who decides that? Somebody has to make a decision. Who decides it? A judge will make a decision, and what will happen to the law? No. Judges never, they cannot change the law. They have it's an on-off switch. Right government passes it, we're over here. But if the wrong government passed it, right, or if you say the right government passed it, no, this would be an invalid law. And there is no further place on the flow chart. It would be struck down by a judge, right? So that's an end point. Because that's what a constitution is going to do. What if the answer is yes? Is that an end point? No, because if the right government passes it, we've got to keep going in the process. And so the next thing we have to ask is, was a charter right violated? This is bringing in the Constitution Act. This is the 1867. This is the 1982. We're bringing it in now. So, did the right government pass, or was a charter right? To answer that question, you have to understand the rights that are listed in sections 2 to 15 of the Constitution. So you have to know stuff. You can't just look at the chart and find the answer. The chart tells you the process. Your knowledge is needed to actually use it. So, the next question is, because it's a statute, it has to be a statute because we're here, right? And you said that the right government passed it. Then what we ask is a charter right violated? Does the law take away a charter right? If the answer is no, what can you tell me about that law? The right government passed it, and there's no charter rights being taken away.
Valid.
That's a valid law. And everyone's going to have to abide by it. But what if you say, well, no, there is a charter right. You look at those facts and you know your charter rights. You know what's happening in these facts, and you say, that law is taking away a Section 6 right, or a right to mobility, right? So you have to know stuff. You don't find that answer in this. The knowledge is set to the side. This is just the process. So the process is, so if a charter right is violated, what can you tell me about that law? Does it mean it's invalid if a charter right's taken away? A law takes away a charter right. Is it invalid? No, because that's not an end point. So then you have to ask, if it's yes, you have to ask, is it a reasonable limit? Does society accept, not the law, the removal of that right? And that requires you to do an assessment. What do you think? You're a reasonable person. You represent society. And remember, if it's on the fence, it's probably society would not accept that. They only accept it in the obvious situations, taking away rights, right? So, then the question is it a reasonable limit? What if the answer is yes? Society accepts the removal of the right. That's not a good answer. You have a statute that was passed by the right government that takes away a charter right, but society accepts that they should take away that right. This is section 1. When's that exam?
Sometime in the future.
In the very near future. Right government. charter right violated? The society accepts the removal of that right.
So the religion becomes like safe, that's what the person can.
What happens if this is your conclusion in the flow chart? If society accepts the removal of that right, that law is valid. This is the Inca case. All right? What if the answer is no? Is that an input? No, because we now have to go on and ask, was Section 33 used? Was it passed with a 5-year time limit where they said they were taking away the right? If the answer is no, what can you tell me about that law? Walk your way through. The right government passed it, that took away a charter right, that society does not accept, and they did not use Section 33. It's an invalid law. What if the answer is yes, they did use it? What? It's valid.
For 5 years.
And that's an endpoint. So, what does this part of the Constitution always answer? What are the endpoints? And that means, guys, here, watch this little jump of cuteness here. No, that was still a different jump. What's the question going to be?
The Lord valid or not?
It has to be something like that. It's because that's all this ever tells you, right? And if you see a question that says, is the law valid or invalid? You know, oh, that's a constitutional question. They all have to be like that. It may not say that exactly, right? But it'll say something like that. That's the effect of what you're going to have to try to determine, because this is what this flow chart does. Do you understand that? Is everything that we talked about over there?
With the reasonable limit, yes, and the law is valid. Is it valid for that case only? Like if society accepts it, then we're just accepting that they can enforce the law and give punishment or whatever the case may be, or is it actually just, it's valid, it's good to go?
I want to call you a rat bastard because that's the question I try to avoid. It's a very good question.
You can say it, get off your chest and feel better if you want.
I'm going to do my best to answer that, okay? Dealing with that question is super advanced in constitutional understanding beyond this course, okay? That's the thing. But what you need to do is, given those facts and that law, would it be valid in those facts and that law? So, a law always stays valid until it's removed. In most situations, when it's removed, it would be removed completely. But sometimes it's only removed for that type of situation. Okay? So, for us, you'll deal with a fact situation and you'll find out whether the law will be valid in that specific situation.
So I guess a good example currently might be what's going on in Saskatchewan with the carbon tax, where they're arguing constitution against whether or not they can be imposed on them or not.
That would be, can they do it at all? Not can they do it about that. So there's a debate going on in governments about whether or not, and it's this, it goes right back to this, did the right government pass the law? Is a carbon tax part of what was given to the federal government in 1867 or not? The ability to deal with environmental issues.
And put additional taxes on provinces.
Yeah. And especially when we're talking about different ways. And there's a part of the Constitution that is a very, again, it has so many different meanings that I don't deal with it in this course because it would just add to a confusing situation and make it even more confusing for you. So there's a bunch of stuff that I don't talk about because it gets too difficult. This is already hard enough, right? So there's an area that was given to the federal government that I never told you about. And it's actually that area that the federal government is trying to use. The question is, does it really fit there or not? If it doesn't fit there, they don't have the right to do that. Going over on the left side, there's no way you could have done this because I never really taught you to because I generally teach it only when we go through the flow chart. So I told you the governments can't behave in a way that takes away charter rights. And the way that you would get to this is if you have a situation that you identify maybe a constitutional question and we're dealing with a behavior. In other words, there is no statute, but there is a behavior. Somebody's doing something. Well, the first question I would ask is that person a private person or are they acting as a government person? If they're acting as a private person, what can you tell me? That is an endpoint. You have a behavior by a private person, not a government person. What? I don't think so. I didn't quite hear you, but what?
I was saying they don't have the right to, well, it's not really a law, it's maybe
There isn't a law, there's a behavior. So I'll give you a fact situation. You know, can I have your name?
Hong.
Ong?
Yeah.
Close enough?
Yeah,
Try
it's
for that
enough.
tonight. Okay, so she decides to drive home tonight, and she wants to give him a ride, and she says, you know, sorry, boys have to sit in the very back seat of my bus. They're not allowed to sit up front. I don't like the way they smell. Right? Whatever. If she does that, we're going to be here. So is that a statute or a behavior?
here.
Is she a private person or a government person? Private. So that would take you to this point in this chart. What can you tell me? It is not a constitutional question. You're done. It's not a constitutional question. This Constitution has nothing to do with what private people have to do. What if it's a government person? Then we have to ask, is he charter right violated? We don't ever deal with this because we can't, because that'll only be a statute, right? So did they take away a charter right? So if the answer is yes, either yes or no, right? Either a right's been taken away or not. This is an endpoint as well. If you say no, what they did does not take away a charter right. So let's say Murray asks everyone in the class to stand up, okay? And everyone does. Well, if I give you that as a fact, and you have identified this as a constitutional issue, well, are we dealing with a statute? Is there a law that says everyone has to stand up? No. A behavior, right? When I'm in front of your class, this is a government institution. Am I a government person or a private person? I'm a government person. I'm a public, not a public person when it comes to defamation. But when I work for a government, I am a government person, right? So I'd go over here. Is a charter right violated when I ask everyone to stand up? I can't think of one, right? Right? Your mobility right? No. Your right to sit in your chair? No. I don't know. So it'll be yes or no. What if it's no? It is. What is that endpoint?
Not a constitutional issue.
It isn't. It's not a constitutional issue. What if the answer is yes? Yeah, we don't go to section 1 here, because section 1 only applies to laws. So this would say, okay, they get a remedy. It's up to a judge to determine appropriate remedy. Are there any questions about that? Go ahead.
It's about the statute. So, actually the answer is, the answer asking if section 33 will be used, the answer is yes. What's the, is that valid?
So if they use section, I need you to, I don't just want to tell you the answer, okay? That won't help you. I need you to sort it through. Okay, here's the facts. Walk your way through, okay? There's a statute that was passed by the right government that took away a charter right that society did not accept as being a reasonable thing for them to do, reasonable limit, and they used section 33 to pass the law. Tell me if that law is valid or invalid. It's valid. What if they didn't use section 33? That's your answer. Okay? Way better if you understand it and can do it yourself. Any other questions?
Where does common law fit in?
It doesn't. It really has nothing to do with this. This is primarily about government's ability to pass laws. That's all of this is about government's ability to pass law. And when a government passes law, it will be a what type of law? Statute or common law? So what does common law? What's this have to do with common law? Nothing. This has to do with government's ability to pass laws, which is statute law. It's a limit on government's abilities to pass statutes, which only impacts really on statute law. Anything else? When you watch me do it, it all makes sense, hopefully, and that makes it look easy. But if you couldn't do it by yourself, that means it was hard. Don't forget that. Okay? And we're going to do it again. I need to move on and talk to you about negligence before I deal with this. I just have to check and see if it's my phone that's making terrible noises, because some morons are doing chat behind the scenes. No, it's not mine. Mine should be on mute. It's okay. I'm not looking to find out where that noise is coming from. I just wanted to make sure it wasn't me. All right. So, we've dealt with this. We're now going to deal with this. This is the little piece that I never finished off last class when we were talking about negligence. So, this should have been dealt with when we talked about negligence, but I didn't have time, so we're going to deal with it now. If you read your textbook, and this is primarily the reason why I even talk about this, is because some people do. Not that many, but there are a few that do. And when you do it, you will come across these, and they can be confusing if I don't explain to you what they are. Negligence comes in many flavors, but no, the flavors do not change what I taught you. So what I did deal with last week was the flavor of negligence that's called occupier's liability. Occupier's liability is basically a rule that says you can be sued for not taking proper care of the building or the people in it or the way that it's managed. It has to do with the fact that when you occupy a building, you have a responsibility to make sure that it is safe. Okay? So, the example I gave you last week was if there's a piece of loose carpet. But with that in mind, if I never taught you about occupier's liability, if you never heard of it and you walked into the exam, you would deal with the fact situation properly. There's a choice, it's unintentional, and then you would go through the elements of negligence that I put up on the board. You do it all right. So knowing about occupier's liability should make no difference. It's sometimes useful to know, though, that the court holds people responsible for the buildings, and it's been lots of things. Having a sign fall down. People have signs over sidewalks from their buildings, and they don't check them or inspect them, and it falls down and hits somebody. Well, that's negligence, right? It's technically occupier's liability, but that's just a type of negligence. Ice and snow, very, very common issue. It's occupier's liability. Anytime people get harmed because or within or control of a building, that's occupier's liability. Okay. And then you still have to go through the exact same steps, right? It doesn't change anything. The next ones don't change anything either, but they're basically telling you some very specific rules about this. What would a reasonable person have done? Okay? So these ones are basically manufacturing liability. And people who produce products can get sued if they don't do it well for negligence, right? So if you design a barbecue and you decide you're going to sell a barbecue, right? Like a gas barbecue. And you have very sharp edges that you fold underneath, but it's where everybody grabs it. When you grab a barbecue, folks, you grab that lip underneath. What if they're like sharp like razor blades, right? And you let them stay sharp? You would get sued for negligence. And what this is telling you is that when you manufacture something or design something, a reasonable manufacturer wouldn't design it that way. So if we take that sharp edges example, would a reasonable person in the position of the defendant foresee that if they leave edges sharp on a barbecue where people grab it, someone could get hurt? Yeah, right? It's pretty foreseeable. And what this law tells you is, what would a reasonable manufacturer do? And what's the answer?
Manufacturer without razor blade and sharp.
Yeah, don't do that, right? So that is telling you an answer to that element. And when it comes to this, they wouldn't do it. So if they have, the court's going to say that's unreasonable. You failed to act reasonably by doing that. And then the only other questions are, is there harm? Yeah, I cut my fingers. And if you hadn't left those edges sharp, would I still have cut the fingers? Is your choice the cause of my harm? Yes? Bang, we got negligence. Okay? So again, this manufacturer's liability is telling you, in this specific type of situation, an answer to number 2, which is what would a reasonable person do. There are 2 other aspects that come up on your manufacturer's liability. So the other 2 are failing to warn. Failing to warn is not what a reasonable person would do. A reasonable person would warn. There are 2 things that come up. And the first failure to warn is of a known danger. You cannot have people exposed to a known danger without warning them. A reasonable person would not do that. So, have any of you used a hammer in the last year? How many of you have used a hammer? Put up your hands if you used a hammer. Okay? Do you know what it said on your hammer?
No.
It did. It said something on your hammer. It did. It said something on your hammer. And it isn't, don't hit your thumb. Okay? What's it say on a hammer?
May cause harm if it fails to use properly.
No, it's not that vague. All hammers that I've seen recently in the last 10 years have this one thing on it. 3 words. 4 maybe. Always.
For protection.
What type of? Especially when you're hammered. Okay. It says wear eye protection. Why? Because when you hit a nail with a hammer, what happens? A piece of metal from that can come up, hit your eye, blind you. And probably someone sued and won because they didn't warn, and now the warning's there. Because the court held that not warning people of a known danger, that pieces can fly up in your eye, is unreasonable. And they got sued. Could a reasonable person foresee that if you don't warn them of a known danger, someone could get hurt? What would a reasonable person do? The courts say they would warn them. Right? And you didn't, so you failed to act reasonably. Was there hurt? Yeah, Johnny hit his eye. And if you had warned him, would he still have hit his eye? That's a tough one, but because you'd have to wear them, and who does? Right? But at least it puts them in a situation. What's the most famous case about this?
Coffee.
Is
McDonald's out of the States and not having a hot warning on the cup.
The details about the case, though. That water was way hotter than normal production levels.
McDonald's won that case.
Wasn't that settled out of court?
McDonald's won that case. You don't have to warn about obvious. You don't have to put on bullets. Don't use these on human beings. Okay? You don't actually have to do that, even though, you know.
It's actually against the Geneva Convention to the bullet anyway, so.
No, my understanding is that McDonald's won that case. And then everyone thinks they lost it. Why? Because when you look at a coffee cup, what do you see? It still says that. You go, oh, I know why it says that, because there was a case. They eventually, my understanding is that they eventually won that case on the basis that you don't have to worry about known dangers. Then why does it still say that?
So nobody else can try to sue them later on.
And ink is free, folks. Right? If you look at a coffee cup, does it matter whether it's got 3 dots or a circle or words on it? Does it cost them any more? It costs them nothing. And it's actually good advertisement. What do you want to put there? Our coffee is lukewarm, right? Like, it's actually pretty good advertisement. Does it say it on that cup that you have in your hand there? Forbidden favors, I guess, is a lawsuit
No,
waiting
it
to
does.
happen.
Caution on content hot.
Oh, content's hot. Okay, just the contents.
They sell soup in those too.
Huh? They'd be hot too. All right, so the law is a reasonable person would warn of a known danger. The last one is improper use. Sometimes people use things for things they're not supposed to. If a manufacturer knows that these are being used, they have to put a warning saying, don't do this. So this takes me back to when I was 3 or 4 years old and invented bungee jumping. So when I was 3 or 4 years old, I invented bungee jumping. Do you know how come I did? Because I found these elastic bands that they were sealing the sewer pipes with in our street. And they were seriously about 6 foot long and about 2 inches thick. And they were really nice and stretchy. So me and Peter Amonier went up on a tree and tied this thing, and we were jumping out of the tree with these elastic bands. Went just about hit the ground and went flying back up. It was lots of fun. So I want you to imagine a situation where somebody finds these bands and says, hey, I'm going to use these for bungee jumping. And the manufacturer knows that people are using these. They have to put a warning. Do not use these for that. And if somebody does and they get hurt and they haven't warned them and they knew about it. So as a final understanding of this, I'm going to say 4 words. Not forward as in forward. 4 words. And I want you to put up your hand if you know why. Ready? Diet, cola, and Mentos. Put up your hand if you know why. Anna, do you know why? You're not sure? Would she be sure, folks? If she knew why, would she be sure? Yeah, she would be sure.